Good afternoon. My name is Edith Jones. I'm a judge on the Fifth Circuit Court of Appeals, and I'm very happy to be the moderator for this showcase panel in the Federalist Society conference. It's on the powers of the executive office and the limits of those powers. The discussion among the panel was centered around the following propositions. The Constitution prescribes the president shall take care that the laws be faithfully executed and swears an oath to that effect upon taking office. Many believe that the Constitution contemplates that the president has significant discretion in handling his office. At the same time, however, norms have developed to control the exercise so that the presidency is not used as a tool to punish enemies or reward political friends. The question our panelists will be addressing are, how does the rule of law constrain and protect the presidency? What role do these norms play? Have norms surrounding the president's exercise of power eroded? And if so, why? What role have Congress, the media, social media, and other factors played in the exercise of the presidential power? Our distinguished panel of speakers begins with Professor Jack Goldsmith of Harvard Law. As you see in your virtual programs, the bios for each of our speakers are very long. I will cut to the chase. He is a learned hand professor at Harvard, a senior fellow at the Hoover Institution, and co-founder of the site Lawfare. Two of his most recent well-known books include After Trump, Reconstructing the Presidency, and In Hoffa's Shadow, A Stepfather, A Disappearance in Detroit. Our next speaker will be the Honorable Theodore Olson. Ted is a partner at Gibson Dunn in Washington, D.C., founder of the firm's crisis management, sports law, and appellate and constitutional law practices. Mr. Olson was Solicitor General of the United States from 2001 to 2004. From 81 to 84, he was Assistant Attorney General in charge of the Office of Legal Counsel. Except for those periods, he has been practicing consistently with great distinction at Gibson Dunn. He has argued 65 cases before the U.S. Supreme Court. Our next speaker beyond that will be the Honorable Neil Eggleston, a partner at Kirkland & Ellis. He is a litigation partner with a distinguished record of public service, including a number of senior government roles. He was White House counsel to President Obama from 2014 to 17, and earlier in his career served as Associate General Counsel to President Clinton from 1993 to 94. He has broad experience in government and in the private legal services. He clerked for Justice Warren Burger on the U.S. Supreme Court. And finally, we recognize Ambassador Boyden Gray, founding partner of Boyden Gray and Associates, a law and strategy firm in Washington, D.C., focused on constitutional and regulatory issues. Mr. Gray worked in the White House for 12 years as counsel to Vice President Bush during the Reagan administration and as White House counsel to President H.W. Bush. He was counsel to the Presidential Task Force on Regulatory Relief, an area in which he has had a professional interest and tremendous impact for many years. He was the U.S. ambassador to the EU and U.S. Special Envoy to Europe for Eurasian Energy. He is on the board of directors of the Atlantic Council, the Federalist Society, among others. And Mr. Gray clerked for Earl Warren, Chief Justice of the United States. We'll begin with Jack Goldsmith. I turn it over to you.
Thank you, Judge Jones. Thanks to the Federalist Society for inviting me to be on this panel. I'm honored to be on this distinguished panel. So So the conventional wisdom is that during the Trump administration, the laws and norms that regulate the limitations on the president's interference in the law enforcement process, and in general that regulate the president's supervision of the law enforcement process, have been disregarded, damaged, thrashed, and the like. And there's a large element of truth to this. And I just published a book, one part of which, 5 chapters, is devoted to assessing this and suggesting reforms. But today I want to take a different tack and suggest that the norms and laws have been more prevalent than maybe that many people have appreciated. And I want to do so by asking about the extent to which the way that norms and laws have operated during the Trump administration are consistent with the theory of the unitary executive, which is obviously a prominent theory widely accepted by members of the Federalist Society and conservatives in the country. So it's actually hard to find a canonical definition of what the unitary executive is. Attorney General Barr at the Olson lecture last year described it generally as the idea that executive powers must be exercised. Executive powers, all of them, they're all vested in the president, and they must be exercised under the president's supervision. And the unitary executive has many components. Part of it is about the president's power to fire subordinate executive branch officials. Part of it is about the president's control over the administration. Part of it is about law enforcement and the president's supervision of law enforcement, and that's what I'm going to focus on. Professor Calabresi and Christopher Yu, in their great book on the unitary executive, state that the unitary executive ensures subordinate executive branch officials will, quote, execute the law in a consistent manner and in accordance with the president's wishes. And Professor Sai Prakash and John Yu say in an essay that they wrote that because of the original constitutional design, President Trump ultimately can order the end of any investigation, even one into his own White House. So my claim is that the practices under the Trump administration don't comport with these definitions and these widely held views of the unitary executive. And I'm going to give you 6 examples, and I'll be very brief because my time is brief. First, volume 2 of the Mueller report, where the most extraordinary element of which is that the president of the United States tried desperately to get his senior subordinates in the White House and the executive branch to fire Mueller and to stop him from continuing his investigation. And he utterly failed, and he failed because those subordinates simply wouldn't carry out his wishes. And we don't know exactly why they didn't carry out his wishes, and there were many of them, but it probably had to do with some combination of law. Maybe they were worried about obstruction of justice, the norm against interference in ongoing investigations that are concern the White House, or maybe political concerns. But it's really a remarkable episode. Second, I'm going to move on and give 5 examples that involve Attorney General Barr, who is obviously a proponent of a broad conception of the unitary executive. He gave a robust defense of it last year at the Federalist Society. At his confirmation hearings, he acknowledged that a presidential pardon to someone to prevent testimony about illegal acts would constitute criminal obstruction of justice. So that's a limitation he recognized on the president's law enforcement supervision. In his famous obstruction of justice memo, he said that the president can commit obstruction of justice if he knowingly destroys or alters evidence, suborns perjury, induces a witness to change testimony, or deliberately impairs the integrity or availability of evidence. Another restriction that he recognized under extant law on the president's supervisory powers over law enforcement. In response to when Attorney General Barr recommended the sentence reduction for Stone in his sentencing hearing, very controversially, and the president of the United States tweeted in favor of that, the Attorney General went on television that evening in an extraordinary interview and said, "I'm not going to be bullied or influenced by anybody, including the president. I cannot do my job here at the department with a constant background commentary that undercuts me. I think it's time to stop tweeting about the Department of Justice criminal cases." Another example is Barr and Trump's extraordinary failure to remove Jeffrey Berman at the Southern District, the U.S. Attorney in the Southern District, whom the president didn't appoint, another solecism for the unitary executive. They were not able to remove him and replace him with either of their preferred choices, and they ended up replacing him with his first deputy, which was Berman's preferred choice. And after they did so, Attorney General Barr issued an extraordinary statement where he said that that the norms of let me get this right. He said that he recognized the norm against improper interference in a case by the Justice Department. He stated that if any actions like that occurred, that the proper persons in the U.S. Attorney's Office should notify the Inspector General of the Justice Department, another entity that is hard to square with the unitary executive and that Attorney General Barr has long criticized, and that the Inspector General would examine any such claims. And my last example is Attorney General Barr's simply not following through on the wishes of the President of the United States to prosecute his political enemies, which the President's called for in many contexts and on many occasions. So these examples I went through quickly. There's a lot to say about them. I think they're all hard to square with at least the casual conventional wisdom about the unitary executive. They suggest that even in an administration of lawyers deeply committed to the unitary executive, they recognize that Congress can constrain presidential power to enforce the law, and that executive branch norms can and do constrain maybe not the president, but his subordinates in carrying out his commands. Now, you might respond, one response that one might make is that the president still has the firing power, another core power of the unitary executive, and he could fire everyone involved in these acts of either seeming insubordination or non-compliance with his wishes. And you might think that that shows that the president has ultimate control, and that's the kind of nub of the unitary executive. And it's true that the president could have fired McGahn and Barr for the actions I just described, people who were notable proponents of the unitary executive theory. But it also shows that Don McGahn and Bill Barr believed in these norm-based and law-based constraints in these various contexts, even holding their broad conceptions of a unitary executive. I also think that the president's power to fire, while it's important in these contexts, it's at least as an absolute matter, purely theoretical. The fact of the matter is that a president who loves to fire people and loves to exercise hard presidential powers failed to exercise them in all 6 of the examples that I used, and he acquiesced in these developments. And I believe that any theory of the unitary executive has to explain these developments. There's more to say, but I'm out of time, so I'm going to turn it over now to Ted, who's next.
Thank you, Jack. That was very interesting. I have been reading your book. Someone should hold up the book so that everybody could see it. After Trump, Reconstructing the Presidency. It's a very, very interesting book written by you and Bob Bauer. And a lot of the book talks about violations of norms that have been attributable to the presidents over time, particular, and you discuss many presidents besides President Trump, but you focus a lot on President Trump, and you make a number of recommendations with respect to changes that might be made in the powers of the president or limitations on the powers of the president. So I'll just talk a little bit about that. I think one observation that I might make with respect to what you've just described to us as violations of the concept of the unitary executive, where the president may have expressed something one day and the people who worked for him, either in the White House counsel's office or Attorney General Barr, didn't do what the president seemed to want to have done when he made those statements. Now, I think anybody who has observed President Trump over this period of time knows that he tends to speak whatever's on his mind at a particular time, sometimes in an interview, sometimes in a speech, sometimes in discussion with the press, sometimes on tweets and things like that. And sometimes he means them and sometimes he doesn't. And it's difficult for those of us who are on the outside to know whether he means them. I think Don McGahn and Bill Barr developed a rapport and relationship with the president that allowed them to exercise certain judgments with respect to whether they wanted to follow through, knowing full well that the president could have fired them if he was unsatisfied with the fact that they didn't comply with his wishes. This business about Berman in New York City, of course the president could have fired the U.S. attorney in the Southern District of New York, but he didn't. He put pressure on the situation so that Berman left, and maybe he did, maybe he didn't get the person that he wanted to substitute for Berman. With respect to the sentence reduction of Stone, Attorney General Barr may have said, I'm paying no attention to, and I'm not being bullied by anybody, but he did change the recommendation of the Justice Department with respect to the sentencing. And as far as I know, as far as I can recall, the judge actually changed the sentencing from what was originally proposed by the staff, who was so unhappy about that. It seems to me that, and I should acknowledge a bias, having served as Assistant Attorney General for the Office of Legal Counsel, a bias in favor of, and as Solicitor General, a bias in favor of the unitary executive, a bias in favor of presidential powers. And I might echo a little bit of what Bill Barr said at the Barbara Olson lecture last November, that there have been many, many instances over time where Congress has limited or purported to limit the power of the president, not necessarily to the good of the idea of the unitary executive, and in many respects doing great damage to that concept. You talked about potential removals of president's subordinates. He should have the power to be able to do that. If he's going to be able to execute the law faithfully according to his judgment, he ought to be able to remove subordinates. Congress has created the whole concept of independent agencies, which contain restrictions on the powers to remove those officials, which are inhibitions on the president's ability to enforce the law. President Roosevelt, if we go back, President Franklin Roosevelt, go back as far as that, said the government was too complicated. It was very difficult for him to manage the government. And if the president is supposed to manage the government by faithfully executing the law, he needs to be able to remove the people who have responsibility to enforce the law. President Kennedy famously said at one point in answer to a question at a press conference, the reporter asked him something and he said, well, I agree with you, but I don't know whether the government will. Many, many other examples of inhibitions on the president to do his job. One of them that stands out in my mind, and it was something that was mentioned and discussed in detail by Attorney General Barr last year, is the entire concept of oversight by Congress, congressional committees, into every aspect of what the president and his subordinates or her subordinates do. Someone's calculated the number of committees that oversee the Defense Department, but it goes on and on and on. Congress requires reports constantly from executive branch agencies to explain what is being done, what isn't being done, why it isn't being done. There are subpoenas to, sometimes subpoenas to members of the administration to come and testify. The number of times that people have to testify are very substantial, and it takes a great deal of time to do that. Those are theatrical events in many cases. They're highly partisan. They are not. They're theatrical, and they're not terribly constructive. Then there's the whole idea of special counsels, independent counsels, and things of that nature, which we know over time have interfered with the ability of the president to exercise his or her responsibilities. Then there is the investigations of presidential actions, which we've seen in bold letters during the Trump administration. Those investigations that are terribly intrusive, and I'm not saying that they haven't always been justified. I'm just saying that when there's a constant investigation going on of the president, from the time he takes office to the time he leaves office, when he's got to respond to leaks from investigations, and sometimes there are and sometimes there aren't, that is an enormous distraction to the presidency, and it's a distraction to the president's ability to enforce the law. So then there is the advice and consent situation where Congress and the Senate frequently does not permit presidential appointments to the executive branch to be confirmed in any reasonable period of time, leaving vacancies. I did a calculation on the number of times cloture was invoked during the George H.W. Bush presidency, 1, during the Clinton presidency, 10, during the George Bush administration, 4, during the Obama administration, 17, and I hope everybody's keeping count of that. That's about 30 altogether. During the Trump administration, 344. It has been very difficult for the president to fill his executive branch with people that work for him. So anyway, I've gone on a long time, but I've seen erosion of the power of the presidency. And I've looked through Jack and Bob's book, and I see these many additional restrictions being suggested. And I think that's not necessarily a good thing for the presidency or for the Constitution. And I'm turning it over to Neil Eggleston at this point.
Thank you. I'm unmuted, right? So thank you, Ted. Thank you, Judge Jones, for your introduction at the beginning. I also want to say that I'm honored to have been invited to be a participant on this panel by the Federalist Society. It's quite a distinguished panel, and obviously the topic is timely and quite important. And for those of you who didn't pay any attention to my biography when it was read, I just want to remind people that I have worked in the White House for 2 presidents. I worked in the first term of the Clinton administration, as well as President Obama's White House counsel. In that role, I obviously got to know Vice President Biden quite well. Indeed, his office in the his West Wing office was essentially immediately below mine in the West Wing, and I saw him quite frequently. As I've thought about this topic, and I'm going to focus on the topic first and probably come back to some of the issues that some of the people talked to at the end of what I have to say, although I'll probably run out of time and we'll do it in the discussion. As I've thought about the rule of law, I really do think that the overarching principle, as articulated by Judge Jones, is that the instruments of government must be used for the benefit of the country and not for the benefit of the occupant of the White House or his, and hopefully someday her, political party. We've taken to refer to some of this as norms. And as to certain aspects of it, I agree that it is a norm, but I think the fundamental concept is more than a norm. I think it's enshrined in the actual language of the Constitution. And although this president ignored it, it should not be ignored. And that is the embodiment of the take care clause of the Constitution in Article 2, which says the president shall take care that the laws be faithfully executed. That is one of his duties in Article 2 of the Constitution. And I believe the faithful execution of the laws requires him to make decisions and execute those laws and make his decisions in a manner of benefit to the country and not of benefit to himself personally. In addition, I want to remind people that the oath of office is actually set forth specifically in the Constitution. The framers, and those of you who read the Constitution, probably have the same reaction I do. If you get rid of all the sort of the amendments and you go back to just the original Constitution, there's not that much language in there. But the framers decided to put the language of the oath of office specifically in the Constitution that the president had to give when he was sworn in. People may remember that when President Obama was first sworn in, there was a little mix-up between him and Chief Justice Roberts, and they actually did the oath of office again the next day. I think there was some concern. I wasn't in the White House then, but I think there was some concern about if he hadn't given the oath exactly as it was in the Constitution, would there be a claim later that he had never actually been sworn in? The take care clause, and both Jack and Ted know this better than I do, is frequently cited, particularly in OLC memos, they certainly were to me when I was White House counsel, as essentially an expansion of the power of the president. So whenever I got a memo from them on national security issues and the power of the president, national security issues, I knew I was going to read about 3 parts of the Constitution that provided the president with power to do whatever, they were seeking to do in the national security space. And that's the vesting clause, the commander-in-chief clause, and the take care clause. The take care clause was used and cited as an expansion, if you will, of the power of the president. I don't think, frankly, that's the way the framers thought about the take care clause. I think that the fact that the oath contains the language that the president agrees that he shall take care, that I will faithfully execute the office of the president of the United States. I think the take care clause was intended to be a constraint on presidential power, not an expansion of presidential power. And for those of us, of you who are originalists as part of the audience or on this panel, I believe the historical record would show that more than today, actually, the concept of the oath was quite important and quite revered, really, at the time of the founders and the drafting of the Constitution, and it had more significance than it really does today. So thinking about, and so the point I wanted to make was much of this you can think of as norms, but the constraint in the Constitution that the president take care that the law be faithfully executed, in my view, is not a norm, it's a requirement of the Constitution, and it's a solemn obligation of the president that the president agreed to when he took the oath of office. What does that mean in practice? It means the president should not be calling for the Department of Justice and the FBI to prosecute his opponents in a presidential election days before the election. It means the president should not be firing the director of the FBI in order to take pressure off the Russian investigation. It is not being contemptuous of the Hatch Act. If you think about it, the Hatch Act essentially mirrors the take care clause in so many different ways, which is the principle is the taxpayer dollars, the dollars paid by all the taxpayers, regardless of which party they're supporting, which pay the salaries and the rent and the electricity of the White House and various parts of the executive branch, should not be used to influence the outcome of an election, particularly in favor of the person who's currently in the White House. And so in my view, part of the respect for the take care clause is not being contemptuous of the Hatch Act. And I think it also means not directing the withholding of crucial military aid to an ally unless that ally announces an investigation of the president's political opponent. As you all know, I could go on and on and on this list. Now, Ted sort of responds, well, he just talks off the cuff. He says things, he doesn't always mean them. Jack says, well, he didn't always get people fired. He didn't always follow through. I know that probably lots of people on this call were not thrilled with the interview by Leslie Stahl, but she did say one thing I think everybody has to agree with, which is that the president of the United States is the president. He is not somebody's crazy uncle. And when he speaks, people listen and pay attention. And I think we've seen that over the last several years. Let me just address sort of Jack's unitary executive argument just for a second. And I think the basic principle has been that the president had tried to do a lot of things that the members of his administration essentially would not go along with and wouldn't let him do. I have to tell you, and I think we've already seen certain aspects of this in the last week or so, I think I'm pretty right that if the president had been reelected to a second term, we would have seen very different people at the senior levels of the executive branch and people who would have followed those commands by the president. He's already fired Mark Esper. He's fired a number of other people. Most of the senior leadership of the Defense Department are now gone. This has all happened after, I believe, he's lost the election. I think that we'll see a number of additional firings to come. And I think, Jack, I just got to say, it may be that he made decisions about who he would surround himself with in the first term. I think that if he had been elected to a second term, we would have had a very different sort of composition of the senior executives at the various different agencies, who would have been much more willing to follow through on the tweets and commands and the like that the president would have continued, and I think probably would have increased the frequency and volume of those demands. Just a few other sort of thoughts. I mean, I heard Ted talk about the investigations and how debilitating they can be. You know, Ted and I are old enough to remember the Clinton administration. I was involved, essentially, I was there in the first term, but remained involved because of the Whitewater investigation throughout the second term. President Clinton was under investigation from day one to the final day of his administration, and subpoenas showed up every day. In some ways, President Trump simply decided not to cooperate and ended up litigating all these various different issues up through the Supreme Court, certainly through the DC Circuit and up through the Supreme Court. It was a very different response. Obviously, the Senate, which was Republican, did not really investigate the White House, but the House attempted to, and largely President Trump decided not to cooperate with the House. So although there were some efforts at investigations, I really think that not all that much happened. And then the last point I just want to talk about is Ted's reference to the various different filibusters. And let me just say, ultimately, obviously, the filibuster has been voted down and abandoned. I'm not going to offer my views on this now, but I'd be quite interested and have wondered if people in this organization or other conservative organizations would have talked about the president penchant for using acting appointments and performing the duties of appointments to fill out the senior ranks of his administration. You know, Ted, for most of these, there hasn't been a filibuster. He hasn't nominated anybody. So there's been nobody to filibuster, and there is no more filibuster. The Constitution requires that the president nominate people for these positions so that the Senate can provide advice and consent. That is the theory is in the Constitution. There is a constraint on the president's power to fill out the senior ranks of the various different agencies. And that's explicitly in the Constitution. That isn't made up by somebody else. And yet the president has sought to avoid that. I'm sure everybody on the panel knows, and most of the people probably in the audience but Justice Thomas, in his concurrence, I guess, I can't remember which, it was a dissent or a concurrence on Southwest General, which was one of the Vacancies Reform Act cases that I was White House counsel at the time and lost. And so I know that case pretty well. But Justice Thomas commented about whether any kind of acting appointment would be constitutional because of the explicit provision in the Constitution that the senior executives be nominated by the president and subject to advice and consent by the Senate, which are explicit terms in the Constitution. So in any event, I very much have appreciated this and looking forward to the discussion later. And I'll turn it over to Boyd and Gray.
I thought I'd unmuted myself. I hope I have. This is a great honor to be on this panel, to follow a successor of mine, I suspect. And I know everybody on the panel, and my father, who was, as I suppose I was for the first part of my life, but he was a born and bred Southerner. If he knew I was on this panel, he would have said, "Son, you are really in high clover." And so that's the way I feel about it. I want to talk about an area of the law, rule of law, which may seem counterintuitive on this panel, but talk about an area where I think, as a conservative, the president has too much theoretical authority, but that authority is being waged by what might be called the fourth branch of government, beyond the control of any branch of government, and that's the question of the delegation of legislative authority to the executive branch. Now, Jack goes into a little bit of this in discussion of the delegation of emergency powers, 76 and 77 statutes, which grant, open season really for the president. Senator Lee has said, gosh, if we don't like what the president's doing, we should stop whining about it. We gave him the authority and we ought to take it back. But I don't view those emergency issues as anywhere near as serious as a much broader question of just the wholesale delegation of legislative power to the independent agencies, which they then interpret in ways that the current law says the courts really can't second guess or judge, notwithstanding the fact that both the Constitution and the Administrative Procedure Act require the courts to adjudicate what the law is. And so I'm talking about the non-delegation doctrine, which I suppose Cass Sunstein said had 230 good years and one bad or something like that. Schechter poetry and Panama refining going back to the Roosevelt era. It's been used as a canon of construction to narrow statutes frequently, and that's a good thing. But we have a situation where the president the executive branch has been given too much authority, too much ambiguity, too many gaps, which they then rush in to fill. And it's very hard for any president, given the limits of the size of the White House staff and OMB, Office of Management and Budget. It is really very, very difficult for any president to monitor the tsunami of regulations that come spewing out of these agencies, and the courts have no basis upon which to make a judgment one way or the other as to whether they comply with congressional intent, because there's not enough guidance in the statute to understand, to use, to utilize, to apply. And I think this is a major cause of our current discontent. I think that it has disenfranchised the little guy to the benefit of the big guy who can cozy up to the big bureaucracies, and the big bureaucracies like big guys because they're fewer to boss around, and it's a question of who really is in charge. Is it the big guy on the outside? Has that big guy captured the agency? It probably has in most cases, and we have some very bad examples, which I could just give 2 or 3, which I will in a second, of where the agency has run off with the power and let the regulated entity or entities or bodies to just do what they want to do. And this is not what the Constitution provides. The Constitution provides the separation of powers, and it's Congress's duty to tell the executive branch what law to apply, not to give it the power to determine what the law is and then to apply it, which is what we have now in our current situation. And the damage that's done to people who don't have ready access with armies of lobbyists to the agencies, they get cut out. And so we have this difficulty of agency supported semi-monopolization, which is bad very, very bad for wealth creation, for innovation, and very bad for the proper oversight or administration of the law. The president can't possibly see that the law is being properly applied with the tsunami that Congress has turned over to the agency. So is there a way to do this? Well, I think, yes, there is. I think the Supreme Court is ready and now has the votes to strike a few statutes down, like Panama refining was done, and Schechter poetry back in the 30s. And I think that would shame Congress into taking back some of the responsibility that it has totally abdicated And this sounds maybe counterintuitive to this panel, but I believe that it is the source of great confusion and maladministration, and very bad for free markets and liberty. And it is a question of separation of powers. It is a question of having the three branches operate as they should. And it means the courts probably have to get in and kick Congress around a little bit, but it's hard for the president to manage what the Congress has just totally advocated. And so I will end there. I hope that, Jack, you will address in a future edition of your book this area of delegation. It's not emergency powers. It's the power over everything else that we do, over everything that we do, and it's a free for all. So I hope you will address that. I hope others on this panel will address it. I've, as the judge has pointed out, or as Neil pointed out, have spent my life worrying about this, and so I'm perhaps a little obsessed by it, but it is something I believe very, very important. And with that, I will turn it back to the judge for further proceedings. Thank you.
Yes, well, we can go in regular order, or if someone has something particular to say. Jack, your turn. Yes.
Could I respond to a few things? So
Sure.
Thanks. So Boyd and I agree with you about delegated powers in the administrative state. And I don't know if you remember, but you were present when we presented an early draft of this book, and you urged us to put that in and address it. And it's too big a problem. It would have taken another book. And so we sliced off the areas of delegated power that were closer to the issues we're talking about, emergency powers, war powers. But I generally agree with what you're saying about the administrative state. I just want to respond to a few things that Ted said. So I too worked in OLC, and I too believe in a powerful presidency. And indeed, a powerful presidency is maintaining a powerful presidency is a premise of the book that Bob Bauer and I wrote. But I don't believe that a powerful presidency, or even the most powerful presidency, is an uncommon. And I don't believe that that is an accurate description of our presidency. And I think that the Trump administration shows that. So I will just say that the idea that the criminal laws constrain the president is not an idea that's new to me. It began with deputy in the executive branch with Deputy Attorney General Silverman's opinion on this issue. He's no slouch on executive power. It's reflected in OLC opinions that pick up on that. And there is some constraint on the president's ability to, and Bill Barr recognized this in the testimony and in his memorandum. There are constraints, and whether they're well enough reflected in congressional statutes is another question. But there are constraints on the president's power to enforce the law when he gets into certain areas. And unitary executive theory needs to come to grips with that. And I think that these constraints are good and important constraints. As for the norms, my point was simply that I think we've seen in this administration that was supposedly violating norms, we've actually seen an extraordinary reaffirmation of them. It's kind of been hidden amidst the flurry of President Trump's rhetoric, but I think we've seen an extraordinary reaffirmation of them. And I think that Attorney General Barr explained why. I mean, he made what was, in my view, a perfectly legitimate suggestion, overruling a subordinate to chancing recommendation. And that was going to be controversial enough. But when the president weighed in and said, "Way to go, Bill, great job, way to listen to me," it appeared as if when the president was interfering in that matter involving a friend of his, Barr said that undermined him, because it did make Barr look political. Barr, I'm sure, was making a legal judgment about what he thought was right, but it made it look like it was political, and it undermined what Barr was doing. And as Barr said, and it's a very good example of how and why we have these norms. A similar example was when President Obama intervened in the Clinton email investigation and said in the middle of it, violating the same norms we're talking about now, that I don't think she meant to do anything to harm national security. And Jim Comey later said that he viewed that as undermining him, as prejudging the case, and he gave it as an example for why he took some of the extraordinary steps that he took. So I think there are good reasons for these norms. I think they're related to political expectations of our society. I think they actually go back to Watergate and conservatives starting basically with Bob Bork's firing of Archibald Cox. And I just think that there are important constraints that need to be taken into account and explained by unitary executive theory. If I could just say a few quick words about the book that Ted kindly mentioned. The book is not all about constraining presidential power. In several instances, we argue for enhancing the power of the Attorney General and ultimately the President. Two examples are, we think that the Mueller investigation showed that Attorney General Barr did not have adequate control of legal interpretations for the executive branch, that the regulations were not adequately clear on that, and that needs to be clarified. We also think that it was a huge mistake that it wasn't clear in Justice Department policies that the Attorney General has to make the hard call, not the FBI director, on a whole slew of things, including opening up criminal and counter investigations of the president. So the book is not just about constraining presidential power. And on some issues, there's been a 50-year consensus that there are certain things like conflicts of interest, corruption, tax disclosure. These are things conservatives were always in favor of. Assistant Attorney General Scalia said that even though at the time the conflict of interest statutes didn't apply to the president, of course every president would want to comply with them. And we're simply suggesting that those norms be converted into law. And the last thing I'll say is that I agree with Ted about the Senate and the confirmation process. So we have a chapter on vacancies where we suggest that the vacancies discretions of presidents, and President Trump is not the first to exercise this power broadly, as we make clear in the book. We do suggest tightening up the president's discretion on vacancies, but we suggest it in exchange, but we acknowledge the point Ted made. It's not just a question of the Senate not confirming. It's also the Congress has now required over 800 executive branch positions to be Senate confirmed. And the combination of the Senate growing increasingly recalcitrant about confirmations and having a higher numbers, there shouldn't be a deal. There shouldn't be a reduction in presidential discretion on vacancies until the Senate fixes that. That is the deal that we propose, and I think that's the only deal that's conceivable there. Thank you.
Ted, would you like to say something?
I would, of course I would. Thank you, Judge. I will say, first of all, that the Jack and Bob's book is terrific because it goes through so much history and in so many different administrations. I don't think they expect everybody to agree with every one of their recommendations. And I do acknowledge that in some respects, it talks about further liberation or further freedom for the president to do some operations. The example that he gave about the allocation or the assignment of power to Mueller wasn't sufficiently explicit and needed to be improved and so forth. Well, that's up to those are Justice Department regulations, and they should, if they want to fix them, they should fix them. I am a big skeptic about special counsel investigations. They tend to go on forever. They tend to create their own bureaucracy. They tend to incentivize excessive use of prosecutorial authority by going after friends and associates and anybody having anything to do with the subject matter of their investigation so that they can prosecute people for events that have nothing to do with the purpose of the investigation in order to coerce cooperation from those individuals. I could go on because I've had a personal experience with independent counsel and investigation. And Neil's comment about it going on for 8 years during the Clinton administration, I don't know the degree to which that inhibited President Clinton's ability to be an effective president. I would have thought that it did, and I thought that President Clinton felt that way. That not only was it the Whitewater investigation, but it was investigations of various members of his cabinet and administration. And it seemed to me to be a tremendous distraction. And we are now we've had impeachments of as a part of the process that inhibits the power of the president if they're not well grounded. And I'm not making any judgment about any of the impeachment proceedings, but those types of things that take away from the power of the president to do what is the vesting clause of the Article 2, the executive power shall be vested in the president. The president needs to be able to do that. I'm skeptical of a lot of the reforms, although the book, that Jack and Bob's book does have some things in it other than reforms. It is a lot of reforms, and it includes dealing with the press and other things. I'm kind of skeptical about these things because frequently these reforms come along and then they're worse than the disease and they never go away. So the framers of the Constitution, and maybe I'll stop at this point, well, maybe two more points. The framers of the Constitution knew that this government was going to be implemented, executed by individuals, that individuals were flawed, that they were sometimes not acting in the best interest, would not be acting in the best interest of the country. Hence the separation of powers, the division of legislative authority, and Boyden's certainly right about that. Congress frequently doesn't do what it should do with respect to congressional enactments to authorize the enforcement of certain laws, because members of Congress don't like to vote on anything controversial because someone might not like it and it might hurt their subsequent election. So they vote for noble phrases like fairness and things like that. But the framers, because they separated the powers, because they thought that they knew that individuals would be flawed, they put in lots of checks, and we just experienced one, an election, to the extent that the citizens of this country did not like the manner in which President Trump spoke, or the manner in which he threatened people, or the manner in which he executed the laws. They exercised their franchise, and we have, and I do believe the election is over. We do have a new president, and we do because a large number of people expressed disapproval, whether one agrees with that or not, of the manner, style, and techniques of this particular president. So we do have a constitution that works pretty well. At the end of the day, we are going to have flawed individuals holding that office, and the people ultimately have the responsibility and opportunity to make a change when they feel it's appropriate.
Neil, have you anything? Yes.
Thank you, Judge. I'll be quite quick, and I think I'm going to end up agreeing with the panel members more than disagreeing with them on this one. Which is, first, as to Boyden, as to the independent agencies, administrative state. We just had SELA law decided only just a couple months ago, reaffirming essentially Humphrey's executor under the circumstance, and so I suppose they could revisit it, although I suspect they won't revisit it all that quickly. I do, Boyden, agree with you that the delegation issue really needs to be looked at. I suspect no legislation is going to get through this Congress, but I would look at IEPA, the National Emergencies Act, some of the national security tariffs, which just provide an enormous amount of unchecked discretion to the president. And I think those are all pretty problematic. Jack would know the details of this better than I do, but a number of these were initially passed in the pre-Chadha era. And Chadha, for those of you who aren't Jack, will remember that's the case where the Supreme Court essentially said that Congress had to act through both houses passing a bill and the president signing it, and couldn't have essentially like a one-house veto. A lot of these, that when Congress provided this much discretion to the president, Congress thought it was going to have this check of being able to have a House vote and overturn whatever the president did. Those were struck down. And for a number of those, so the discretion really remained. I think those are areas that really do need pretty serious look, because there's such an enormous grant of discretion to the president in very significant areas. As to the independent counsel, well, just one point, Ted, I didn't mean to suggest that President Clinton didn't think those investigations impacted him. They very much impacted him. And maybe you hadn't said this, and I was more responding to things that President Trump had said about he's the most investigated president ever. And I think, having lived through the Clinton investigations, I think President Clinton would significantly disagree with that characterization, who had lots of investigations. And Chairman Burton, we just got subpoenas sort of handfuls pretty much every day. And finally, as the independent counsel investigations, I don't actually think the statute is unconstitutional. I know that Ted, you certainly do. I don't agree with Justice Scalia's, I think, lone dissenting opinion in Morrison v. Olson. I do think it's a bad idea. I think the statute puts improper motivations on people, as Ted said, and I think, frankly, we saw that particularly with respect to Judge Walsh in the Reagan era investigations, and frankly with Ken Starr in the Clinton era investigations, which were both unseemly in my view and exorbitant. There's some other examples. I represented Alexis Herman, who had an independent counsel appointed that was by Ralph Lancaster, a lawyer in Maine, very prominent lawyer, nationwide lawyer, happened to be based in Maine, did a very professional, very thorough, low-key, out-of-the-press investigation, and did not use it as an occasion to enhance his own stature. And so it in that sense, like so many things, who you pick can have an impact on whether something is successful or not. But in any event, Judge, that's what I have, and I'll turn it back to you.
Well, before I'll be turning it over for questions in just a minute or two, but I do think it's sort of interesting when all these accusations are made about the abuses of the Trump presidency that nobody understands, I think, or nobody has voiced the depth of what must be disbelief when a president learns that false warrants have been filed with the FISA court in order to obtain very significant surveillance, what he called wiretapping, but surveillance of people involved with his campaign. And then that he was set up in an interview by the former director of the FBI. And then the purpose of that was to leak something to the press over what was eventually considered a totally false dossier that had been funneled through many odd sources for use by governmental investigators, which became a totally baseless prosecution. Now, President Clinton might feel that what transpired with him was essentially the same, but he was not subject, as far as we know, to the same level of surveillance and patent illegality by the levels of government. With regard to Boyden's comments, there is no doubt that the excessive delegation to independent agencies has been exploited. The last 20 years have demonstrated that in a major way. The previous administration, before the Trump administration, exploited it to inflict tremendous changes on our economy in the nature of, for the alleged purpose of environmental regulation. And the Trump administration has tried to roll back a lot of those. The incoming president has already announced that he's going to change all those. And so this delegation of executive authority is leading to ratcheting, uncertainty, instability, and therefore what I fear is a very fundamental challenge to our economy going forward, even totally apart from the pandemic. So with that, I will just shut up. And if anybody wants to say anything in response to that, please feel free, or else I can attempt to start asking questions from the attendees. Jack?
I think Boyden has a question.
Oh, I don't see him there anymore.
Oh, you don't see me? You don't see me?
I see you now, yes.
No, it's just an observation that in keeping with that, the restraints that have been acknowledged in this session, I think everybody on the panel will appreciate the fact that I think that Barr and the president and others involved exercise extraordinary restraint in not doing anything with the Durham report or otherwise pursuing any of the issues, Judge, you just raised about the Steele dossier and the FISA warrants. Just to remind people that Walsh, who Neil, you referred to, not with the kindest approval, I think, that he effectively indicted the president 5 days before his reelection in 1992. And if no president can survive an indictment 5 days before he's up for reelection, and there's no early voting the way there is today. So I just want to make that comment that there's a lot of restraint that has not been acknowledged when you compare it to what Walsh did.
Okay, I'm supposed to announce for Q&A that those who wish to obtain CLE should note the password is and if you are participating by phone and wish to ask a question, you have to dial *9. But I will first recognize Lee Otis, one of the members of the board of the Federalist Society.
Thank you so much, Judge Jones. I guess I do think that theories of the unitary executive recognize, but perhaps in a way that isn't sufficiently discussed, that the authority that has to be reserved to the president is not an authority to dispense with following the law, but is instead authority to control discretionary decisions by other executive branch agents. And that's why, for example, executive privilege won't be available to protect evidence of wrongdoing. And so I guess I'd just like to get people's thoughts about that and how that, I think the devil may be in the implementation of that, but it does seem to me to be a pretty clear limitation on the theory, because otherwise, as Neil says, what is the point of the oath and what is the point of the take care clause? I mean, I do think and I think the framers also probably intended a negative pregnant from the take care clause, which is that the president had the authority had the necessary authority to take care, et cetera. But it does seem to me that's really not, that some of what Jack was pointing to as exceptions or sort of reasons to doubt the theory in practice, which I do agree there may be some reasons to doubt that it really operates fully in practice. But I don't think the proponents of the unitary executive really doubt that the president has to follow the law and that he cannot direct his subordinates to not follow the law.
Jack, do you?
Sure, respond to that. So, I mean, I agree with that, Lee, to some extent. I think, but it begs the question, and I'm begging the question too, and let me explain why. I mean, the question is, what laws can constrain the president? How far can Congress go in constraining the president when he's exercising his supervisory power over the law enforcement process? And some proponents of the unitary executive speak as if, and again, as I said at the outset of my remarks, there's actually no canonical statement of this. And everything I'm about to discuss, I believe, is contested among unitary executive theorists and scholars and practitioners generally. The question is, how far could Congress go? How far has it gone, and how far can it go in constraining the president's discretion when he's supervising law enforcement or a prosecution? So yes, maybe the president can't violate the law, but what if but the question is, how far can the law go in constraining him? And the only point I was trying to make, and there was a discussion about whether the obstruction of justice statutes apply to President Trump. in the context of exercising his removal power. And agreed with Attorney General Barr and his pre-Attorney General memo that the plain statement rule almost certainly applies there. But in other circumstances, Attorney General Barr has recognized that the president can violate the bribery laws and the obstruction of justice laws by engaging in certain actions that Barr never really explained why he thinks so. But I think the theory is that certain exercises of executive power, this is the theory suggested by then Deputy Attorney General Silberman, picked up in some later OLC opinions. The theory is not that the president can't violate the law, but that certain exercises of presidential power aren't proper exercises of executive power, and therefore the president is subject to ordinary criminal penalties. So, for example, the example that I believe Silberman used and that OLC picked up is if the president is subject to the bribery statute because if he accepted a bribe, he couldn't be exercising executive power. Well, matters are actually more complex than that. What if the president was exercising a pardon in exchange for a bribe? On that question, Attorney General Barr said in his testimony that he thought that the president could be subject to liability there. So I don't think that the way you put it makes the problem go away. I think it really enhances and highlights the problem. I don't know exactly where the line is as to how far Congress can go in constraining the president's exercise of supervisory power over law enforcement. I do believe it can regulate it to some extent. The court really has never addressed this in any meaningful way. Morrison didn't really get at this. And so I just think it's an open question as to how far Congress can go, but I think it's more complicated than just saying the president, of course, can't exercise supervisory power in a way that violates the law.
We'll call next Mr. Sean Ross.
Hi, just Sean Callahan. I want to pick up on what Mr. Goldsmith brought up, the 60 Minutes interview with President Obama in 2015. He said he didn't think that the email server posed a risk to national security, and that the investigation, which had already been ongoing at that point, the FBI investigation, was ginned up for political purposes. Of course, later, we know that the emails contained compartmentalized information. We also were served with claims that unsecured emails, even non-classified ones, can be great putative national security crises. Now, it's reported that the Mueller investigation concluded that there was no conspiracy pretty early on, and for about a year and a half investigated obstruction of justice. And among the theories of obstruction of justice was that the president committed the material acts of that offense through tweet.
Mr. Ross, get to your point, please.
So
you have a question?
I certainly do, yeah. So my question is simply this. Is the theory under which the president was investigated for obstruction of justice, apart from style or form, but substance only, is that the same that could have been used to investigate President Obama for the 60 Minutes interview?
Mr. X?
Yeah, why don't you? So I'll take that. So I would just sort of had the same reaction when Jack said it. So President Obama was president for 8 years, and he made a mistake in something that he said on one occasion. And I think to compare that to what President Trump has done on virtually a daily basis, urging the Department of Justice to intervene, either to help his friends, to benefit people under investigation, or to prosecute his Biden days before the election. I think the comparison between those two is sort of wildly sort of misplaced. And just in answer to the question, I would say that the comment that President Obama made, which had pretty much no impact whatsoever, is wildly different from the 7 or 8 instances of obstruction of justice that Bob Mueller found in connection with the president. And on this issue, there's a fascinating legal discussion in the Mueller memo or Mueller report on this very issue of where the line is on what the president could be indicted for in connection with obstruction of justice, because essentially of the unitary executive theory. I'm not entirely sure I agree where Mueller draws the line. I think some of the examples that Jack gave are good. I completely agree with him that the line isn't very clear, but I actually thought it was commendable of Mueller to try to come up with a theory about where the line would be. And I do think that in response to what Lee said, I do think that the principles, though, are basically the same, which is the president doesn't have the power to violate the take care clause. And if the president is acting in violation of the take care clause, he's not acting as president. He's acting as an individual, because the take care clause is in the Constitution, and I believe acts as a constraint. And I think Jack has written some stuff disagreeing with this and talking about the application of the plain statement rule. I'm just not sure how applicable that is to obstruction of justice statutes as opposed to issues like whether FOIA applies to the president. I think it seems to me that's a very different, very, very different application. But anyway, that would be my thought on those issues.
All right. For the speakers, if any of you want to comment, why don't you raise your hands, or else I'll go on to the next question, which is Professor Ilya Somin.
Can you hear me?
Yes, thanks.
Great. So thank you to Judge Jones and to the speakers for your many excellent points. I wonder if I might ask a question about the unitary executive, in that the idea that all the powers of the executive branch should be concentrated ultimately in the hands of one person. That may make excellent sense if the power of the executive and the federal government generally is limited in the ways that it was at the time of the founding. But in the modern executive branch, the executive wields enormous power over all sorts of issues that were not thought to be within the scope of federal power at all at the time of the founding. Just in the area of federal law enforcement authority, the two biggest ones are probably immigration and the war on drugs in terms of the number of people that are affected or detained or in prison. And neither one of those was originally understood to be within the scope of federal power to anything like the same degree they are today. So if we accept a non-originalist vast expansion of the scope of federal power, then it's not clear why we at the same time should be originalist and textualist about the question of the idea that all of this should be under the control of one person. That it seemed to me an executive branch which is vastly more powerful overall than it was under the original meaning. Maybe the solution to that is that just roll back the overall power of the executive branch. But if we are unwilling or unable to do that, then maybe we should be willing to bend on the idea of that all of this should be in the hands of one person. Maybe an executive branch as powerful as it is today, there should be room for Congress to have certain prosecutors or certain other officials that have some independence from the White House, and also the risk of self-dealing by the White House, I think, is much larger in this era, in this situation where the amount of power within the executive branch is so much greater than it would have been at the founding. So sort of that's the question, is the original idea of the unitary executive compatible with the very non-originalist expansion of the scope of executive power and federal power generally?
Ted,
Yeah, I'll take a little bit of a shot at that. It seemed to be that the premise was that because the courts have allowed the federal government to exercise powers that maybe weren't contemplated at the time of the framing, that then the executive power should be limited accordingly. It seems to me that if, to the extent that Congress is exercising its enumerated powers, and the courts have upheld that, whether it be Commerce Clause or immigration or the criminal laws or things of that nature, those create opportunities to execute the law. And the framers went through a big debate over the weekend of the 4th, 5th, 6th, 7th of June in 1787 about whether the executive power, once it's created by Congress, and once Congress has decided to execute or to act on enumerated powers to create laws that whether that the enforcement of those laws should be vested in a single person or in multiple persons. And the debate was like 9-4 or something like that. I can't remember the exact number. That for various reasons, it was not good to put that power in the hands of a multiple persons. And this is discussed, of course, in the Federalist Papers as well. So it seems to me that it's almost tautological, but to the extent that it is a lawful exercise by Congress of the power to create laws, the execution of those laws should be vested according to the first words of Article 2, shall be vested in a president of the United States, not multiple presidents and so forth. And Congress shouldn't be able to control that through constraints on the power to remove. And I will say one more thing about the previous discussion of the president's responsibility to obey criminal laws. I don't agree with Neil that anybody makes the argument that the president is failing faithfully to execute the laws, he is subject to criminal enforcement or something like that, because people argue all the time that the president should enforce this law in a certain way or should enforce this law and that sort of thing. This has got to be more complicated than that. I did write an opinion or testimony to Congress that when the president violates a federal criminal statute, he could be indicted while in office. I know OLC has written an opinion that says that he cannot. I went through the Constitution and I couldn't find a constraint on the authority to indict a president if there was a clear violation of a generally applicable law, not something that Congress comes up with because they want to constrain the powers of a particular president. But generally applicable criminal laws, I would think that the process could be applied against the president.
Thank you.
Can I say something briefly on that? I'm sorry.
Greg Dolan. Oh, I'm sorry, Jack, excuse me. Please, go ahead.
I just want to state very briefly, I meant to Elia, I think what you described should happen, has happened. I mean, there's no doubt that the president has garnered extraordinary power in a generic way, in an increasing way for the last 230 years. It's been rising and rising and rising. But at the same time it's been rising, the kind of constraints that Ted was noting in his opening remarks have been rising. Congress has at the same time the store in terms of presidential discretion to implement laws and do all these things. It has imposed a whole bunch of restrictions on the executive that are novel in the last 50 or 60 years in terms of inspectors general, reporting requirements, oversight requirements, FOIA and the like, everything in Bill Barr's famous memo about 10 encroachments. And I think actually that in addition to outsourcing lawmaking to the executive, Congress has also outsourced oversight to the executive and to private causes of action. And so I think what you've just described has happened, whether it's happened in an optimal way and whether instead of delegating both lawmaking and oversight to other institutions, Congress should be doing it itself. I mean, I don't think it's a great outcome overall, but I think what you've described has actually happened.
Boyden?
Well, I'm not sure I disagree with Jack, but the Consumer Product Safety Commission, which has been referred to, has had its wings clipped a little bit. But I just want to remind people that when its budget, of course, is not paid by the Congress, Congress has given away the power of the purse. Congress, they just originally beyond the control of the president, basically took the law power, the law judiciary power to review away. So it's like Jupiter orbiting in its own little orbit. And when the head of the agency was called to Congress to testify, he didn't have to, he sort of volunteered. He was asked, well, how do you justify spending $200 million on a renovation of your headquarters? And his answer was, what does it matter to you? So that's not a good situation to be in, I think, for the country. So Congress has to step up, and the courts have to give a little boost to congressional responsibility.
Next person in the queue is Gregory Dolan, D-O-L-I-N.
Thank you, Judge Jones, and it's a pleasure to see everybody on this panel. Thank you for similar discussion. I wanted to follow up on what Ambassador Gray was saying for both in his opening remarks and just now, and perhaps turn it around from asking whether or not the president has too much power or too little for that matter, but whether or not Congress has been jealously guarding its own power from creating these independent agencies like CFPB that's self-funding to to kind of, for example, the abolition of filibuster on nominations, which of course, redounded to benefit of both parties, but also sort of gave away congressional ability to really hold nominees to account. And it just seems to me that prior senators like Senator Byrd probably would have never consented to it, but now senators view it less as a kind of exercise of their power and more of a winning in a grander, I guess, policy scheme of things. And so I guess my question is this: can the rule of law survive when instead of kind of jealously guarding instead of each branch jealously guarding its own power, as our founders intended, now branches, as both judiciary accepted, really are looking for policy wins at whatever cost they come? And if that can't survive, what potential prescriptions might we have to restore the balance to the branches? Thank you.
Who would like to take that on?
Well, Judge Jones?
Yes. Yeah.
I think that one of the things, the Supreme Court's been thinking about the degree to which it will continue to defer to the judgments of executive branch agencies under the Chevron doctrine and the other cases that our deference and Chevron deference and that sort of thing. It might be that the Supreme Court renders some decisions saying we're not going to defer to the exercise of the interpretations or regulations of administrative agencies or executive branch agencies, for that matter, when they're exercising power way beyond that which has been explicitly delegated to them by Congress. So what Broyden says is very, very true. And what I said before is that it comes out of the fact, in part, because members of Congress don't want to vote on anything controversial, so they vote on mush, which they then pass on to the executive branch or so-called independent agencies. I can never say the word independent agencies without saying so-called, because when I first came to OLC, I kept looking through my Constitution for Article 1, the Congress, Article 2, the President, Article 3, the judiciary, and this fourth branch of government that everybody was talking to me about, I could not find anywhere. But to the extent that the courts have given too much deference, where Congress was not sufficiently specific about what it intended or what it intended to constrain, then I think that maybe Congress and the agencies will simply have to narrow down the extent of the exercise of their powers.
Anyone else? All righty. The last questioner in the queue is a telephone, 443-567-2869. So identify yourself, please, or unmute yourself. You've got your hand up. 443.
Yes, Your Honor. Can you hear me?
Yes.
Very good. Thanks very much. I realize we're very short on time, so I'll be brief. Just be fascinated at the panel's response to a potential solution. Seems like the ways that unitary executive could be abused are fundamentally either the Congress sort of concedes its power, discussed through writing vague laws and allowing the administrative state to sort of fill in the blanks, that's one danger. The second seems to be fundamentally what could be thought of as prosecutorial discretion. I know that there are a number of fairly controversial Supreme Court decisions that came out of at least the prior administration as a result of that administration electing not to enforce laws that were on the books at the time. So if Congress were to reassert its power, and I realize that may be asking a lot in the current political environment, both by number one, reasserting its power to actually write the law rather than allow it to go through the regulatory process, and then prioritize and appropriate resources or prioritize enforcement priorities and then appropriate sufficient resources and then provide oversight. I'd just be curious as to what extent, I realize this is very hypothetical, to what extent that might address the problem.
Ted?
Well, I'll be happy to speak a little bit about that, but it seems to me that's right down Boyden's alley in terms of what, yes, it would be great if Congress would do that, and it could use the power of the purse, which Boyden pointed out with respect to the CFPB, it had given away completely to the agency to write its own budget out of the Federal Reserve money, so there wasn't any appropriation powers at all. Congress needs to do that sort of thing, and hopefully that there will be some impetus to go ahead and exercise some constraints or quit complaining about the fact that their laws are being enforced in ways that they don't like.
Jack, Neil? Oh, Boyden, yes.
Well, I think I've already said this and enough has been said, but I do believe that the courts are going to have to take the first step to introduce more accountability into the system by kicking out some of these statutes that may be very embarrassing to Congress for the Supreme Court to do this, or very embarrassing to an agency for Congress to say we're not going to accept your interpretation of this statute, which you consider vague. But I think the courts have to take the first step. I don't think they can complete the job. The job has to be completed by Congress. But I really do believe firmly that FELA law, which has been referred to, there's been a case that's raised our type Chevron type issues. I know we're running out of time, but I do want to tell one sort of joke on Scalia that Thomas loves to tell, is told publicly. Our is one of those cases which I think is not going to survive this discussion for too long. After the argument in the other case where our was discussed at great length, at the end of the argument, Scalia leant over to Thomas and said, Clarence, I think that our decision was the worst decision ever rendered by the Supreme Court. And Thomas said, Nino, I feel your pain. You wrote it.
That's very good. Well, I'm going to make an effort for us to conclude on time. I'm assuming nobody else has 15, 30-second remark. Want to thank our distinguished panelists for a very high-level discussion of the issues of executive power. And I think one thing that history has shown us, at least the history of the early 21st century, is that these problems are going to be ubiquitous in the coming years as they have been in the recent past. I also thank Dean Reuter and Julie Nix of the Federalist Society for helping to set this up. And I would like to invite everyone to be on call in 15 minutes at 6 p.m. Eastern Time, when former Judge Janice Rogers Brown will deliver an address entitled Love Letter to the Late Great American Republic. Our keynote speaker, Justice Alito, will do his speech at 8 p.m. Eastern Standard Time. So I'm sure we will all look forward to that. And again, gentlemen, Eggleston, Professor Goldsmith, Olson, Gray, thank you very much for us, and thank you to the audience.
Thank you,
Adieu.
Judge.
Thank you, Judge.